Mr. Unoruka, I would like to ask you, and this follows from what Mr. Additional has just finished saying and all that. At base, one of our previous guests in today's program mentioned that the first rule is that of self-preservation in everything. Are lawyers part of the problem? Because everybody who is talking here is a lawyer.
Yes, definitely lawyers, and in this particular case, the prosecuting counsel are essentially the problem. I'm talking now about criminal prosecution, the reason why matters get stalled. Any experienced prosecutor from the days of yore will tell you that by the time you cluster 13 to 20 people in a charge sheet, and then you have 13 to 20 or at times 100 counts of charge on it, you don't intend to prosecute to conclusion. You intend to just play to the gallery. It's as simple as that. So when you then have this kind of number of counts and you keep amending them every day, and you know the consequences of an amendment, even at the middle of a trial, it sends you the novel. Now, if you start doing that, then definitely you are playing to the gallery, you are pandering to the press, and not trying to get either a conviction or an acquittal. So
I'm sorry, that's on one hand. That's on one hand.
On the doorstep of the prosecutors.
No, you've talked about the prosecutors. Now let's talk about the defense. There is interlocutory injunctions. There are appeals on procedural matters that run all the way to the Supreme Court, right from the High Court all the way to the Supreme Court, on a simple matter of procedure. And when we speak to some of your colleagues, they talk about the fact that it's all delaying tactics. This is on the side of the defense.
With all due respect, any person who curtails the right of a defense counsel to offer the maximum protection that he is capable of offering to an accused person is flouting the provisions of Section 33(1) of the Constitution. The accused person under our administration of criminal justice, the defendant now, has all the burden stacked on him. Never mind that he is said to be presumed innocent. He is the one who is facing trial.
Yes.
And the minutest available weapon available for him to defend himself must be given to him, even if it means that he has to file 100 applications in a day. That is why I am talking about the prosecutor. The prosecutor should be in a position to act and proceed in such a way that there will be minimum necessity for the defendant to object to things. But you cannot put his liberty at stake and prevent him from doing whatever the law permits him to do to get free.
You wanted to say something,
yes,
Mr.
Because I used to be a prosecutor.
Yes.
And the first principle for me was that the case is clearly set out, right? And put before the judge in a way that makes it easier for him to apprehend and deal with. The second issue, I think, is the fact that the system has expanded massively since, even the 90s, the 80s. The kind of cases, we've got kidnapping cases. These are new. We've got terrorism cases. You heard that they're about to start the trial of 2,000 plus suspected Boko Haram. We've got murder we've got armed robbery has not stopped. We've got fraud across the board, financial crimes, etc., etc.
Cyber crimes.
All kinds of crime. Now, I can tell you that no court system in the world can manage this many cases, which is why I always take the manager's approach. What we need is closure, not morality. So, the primary instrument that a prosecutorial authority uses in cleaning up reducing the number of cases to only those that they feel are of such egregious moral disruption that they should go to court and have a public trial is that they use the plea bargain. That's what they use. It's the only instrument by which you can deal with a majority of your case. But we get all worked up, oh, it's a deal and all. But look, we want closure.
Isn't it?
It's when you, and it's a conviction. It's always on your record. It's a conviction. You can't contest elections and all manner of things. But we're very, so that's the primary instrument of control. The second is that, again, no matter how, what do you call it? No matter how many rights the defendant has, the judge has a measure of control over the process. Judges cannot push back the argument and say, well, the defendant has all the rights. No, there's no system that gives you absolute in any sector. So I think our judges are a bit indulgent, especially of senior counsel. They need to get a grip and be more determined to have
Are they indulgent, or some other people have described them scared?
No. I mean, I can't, since I can't look into the judge's mind, but I don't question motive. It's not motive, I question result.
Because there was actually a report of a judge who said he was confronted with 90 senior advocates of Nigeria on behalf of his defense.
Then he shouldn't be there. I mean, he's the one sitting up, he's sitting looking down on them. So that's why they put the judges up there. So, but finally, if I may just add also that, again, something we've been scared of doing in Nigeria is to put time limits on cases. Again, of course you can.
We did it with electoral matters.
That's what I was coming there. Why is the focus so much on this electoral matter?
Well, you answered.
So I'm saying that when we look at the Constitution, we have to, first of all, we have to look at even limiting the kind of cases you can appeal against. In America, it's not even the courts that decide, it's the registrar. Yes. Registrars have the power to say there's no merit here. But in Nigeria, everything goes into the system. There are no filters. So we need stronger filters so that it's only the substantive matters with a bit of merit that will go before the courts.
Let me bring in this and still speaking about the judges. Yeah. I've heard lawyers differ on the question of appointment of judges. Is that a problem?
It's part of the problem. It's part, I must be honest. It's part of the problem. Because, and here, I'm not generalizing. We have to look at specific cases. There are some who are on the bench who ordinarily shouldn't have found themselves there.
True.
But they got there because of who they know. You know, the process of appointment needs to be overhauled. The parameters need to be not on, look at the senior advocate of Nigeria appointment. There was a time once you satisfy the number of cases, that is it. But over a period of time, some 10 years to now, there have been different additional requirements. They have to look at your chambers. They look at your library. They look at the practice books that you have in that library. And then above all that, you sit face to face for interview to determine your standard of learning, and more especially to determine your character. You see, character is everything. So we need to look at all these things and really ensure that we are putting a round peg in a round hole. It is very important.
But then you keep hearing the story of judicial reforms. And all the time, they come up with a long list of things that need to be done, well, and we're all happy. But then we don't hear anything after that.
Sometimes, the thing about human nature,
they are left on papers,
is that sometimes you may have at the beginning an apparently round peg in an apparently round hole. But the nature of man is that such a person can change. It is the institutional structure that should control judges' output, etc. That's why I say you can't look at it as an individual judge. You have to say, how does the institution, in terms of resources, guidelines, regulation, etc., enhance the capacity of this judge to improve its output?
Mr. Noruka, you're going to have the final word on this segment because we're told that we have less than 2 minutes. People have mentioned that part of the anachronistic nature of the judiciary is the NJC, which is the highest decision-making body for the judiciary. And that a lot of the things that you have spoken about so far within this segment of the discussion dovetails into decisions to be made or that have been made by the NJC. Is that a fair comment?
It is a fair comment, and I can tell you that the problem with the NJC started during the Obasanjo regime. Otherwise, before that time, the NJC was constituted in such a way that we could depend on it for integrity. And a very serious business was done in those days. But it was when it was politicized during the administration of Obasanjo that individuals who had no business being in the NJC found themselves in there. And then decisions there became as corrupt as what you find in every other segment of Nigerian society. It's a pity.
What do we do about that? Finally, what do we do about that? What can we do? Very briefly, what can we do?
We should implement the recommendation of the body of senior advocates and the leadership of the Nigerian Bar Association about who should be a member of the NJC. There are spaces reserved in the NJC that shouldn't be there. And then I do not see the reason why representatives of the NBA should only be part members to take to take part in certain decisions, but not in all decisions.
That's right.
Okay, thank you very much. It suddenly stopped in the middle, and everybody seemed to think it. Yes, seemed to get it. Right. So I want to thank you very much. This is our final segment. Let me thank you, Mr. Dile Additional, Mr. Fola Athawari, and Mr. Udechukwu Noruka in Abuja. Thank you very much for joining us on this program today. Your words and your thoughts have been quite inspiring. Ladies and gentlemen.
Thank you.
Well, yes, indeed. What a day it's been.
It's been a real day.
It has been, and it's been very interesting, and we would like to appreciate everyone who has sent a comment or two. This is where we draw the curtains on the show today. But thank you all for watching. I'm Chamberlain Uso.
I'm Ijoma Onya. So indeed, 3 hours is not enough to talk about Nigeria for 57 years. But yeah, we have done what we've done, and Nigeria is depending on you to make things better. Yeah.
Yes, change begins with us, or with you and with me. On behalf of the entire crew, there are many of them who you can't see working behind the scenes who have made this broadcast possible. My name is Ladi Akiri Doluali. Do have yourselves a wonderful, what's left of it anyway, Independence Anniversary. Good evening.